SIA, Veliks and Playtech Software Ltd.
Yes, Mr. Minister.
May it please you, my lords and my lady. I appear for the appellants, the fourth and the fifth defendant, with my learned friend Mr. Key. My learned friend Mr. Speck appears with Mr. Jones for the claimant, respondent. And this is my appeal against the order of Mr. Justice Thompsell dated the 24th of January 2025. There's no respondent's notice and no cross appeal in respect of the order setting aside service out in respect of the claim sought to be brought by the claimant against the first and second defendants, or indeed the third defendant. So there's no allegation against either the first or second defendant before the court. The appeal before you concerns a claim in misuse of confidential information and trade secrets. There is also what we say is an entirely artificial claim in respect of copyright infringement relating to a single screenshot which is inferred by Playtech, the respondents, to contain a particular logo used in one particular game. That was brought in an attempt to found jurisdiction. It wasn't relied on by the judge in coming to his decision on jurisdiction, and the respondents say that they don't ask you to depart from that, but it's unclear whether the claimant contends that the copyright claim on its own should proceed if permission to serve out or the order to serve out is set aside in relation to trade secrets and confidential information. It's said by my learned friend that that copyright claim will have to be tried in England and Wales in any event. That's paragraph 6 of his skeleton. We say that's absolutely not the case. If we're successful on this appeal, and the court is of the view that the confidential information or trade secrets claim should not proceed, we say it'd be wrong for an entirely artificial claim where no injunction is sought, no pleaded basis is given for anything other than nominal damages to proceed on its own here. And of course the evidence before the court was that the copyright claim under English law could be tried in Latvia. So, my lords, my lady, the focus of the appeal is against the order dismissing my client's jurisdiction applications, dismissing my client's application to have the jurisdiction set aside in respect of the confidential information trade secrets claim, and it's not explained, if we're successful on that, why the copyright claim should continue. Just to introduce the parties very briefly, and then I'll set out where I'm going with my submissions. The fifth defendant is a former employee of what used to be the second claimant, which is a group company of the present claimant. And what is now complained of is access in Latvia to an online platform called Horizon, in which some games are said to have been made available before launch, but which contains many other games. There's no pleaded case as to how a user can tell which of the games have been launched or not, but the only games that are relied on that platform were ones that had not yet been launched. And access to launched games, at least, is given to members of the public as well as employees. My learned friend says that that access after the departure of D5 from the employment of the second claimant, as was, but the Playtech group, and after he had joined the employment of the fourth defendant, my other client, says that access amounts to misuse of confidence. We say, in fact, it's merely market intelligence. His access wasn't cut off in any way. He was looking at what was going on in what was the shop window of the other side. There is no allegation of access to another specific development platform where games before the pre-launch access on Horizon was provided, where those games were developed. That was originally in the claim, but that was abandoned. The fourth defendant is now the employer of the fifth defendant, Mr. Veliks. The fourth defendant is a developer of games, and as I will show you, and this is important, there is no allegation that either D4 or D5 carried out any act in the jurisdiction or of any act which has caused direct loss within the jurisdiction. The judge held that there was no prospect of injunctive relief in the UK for either copyright or confidential information trade secrets claims. So he refused permission under Gateway 2. He said they didn't pass through Gateway 2. But the judge allowed the claim to pass through Gateway 9, the wrong claims, tort claim, but also Gateway 21, the confidential information gateway. And he found in the claimant's favour on the forum conveyance analysis, and we say he fell into error in doing so. So with that introduction, the structure of my submissions this morning, it's common ground, I think, that between the parties that the central issue before the court is whether the alleged wrongs relied on in the confidential information and trade secrets claim give rise to, or alleged to give rise to, relevant direct damage in the UK. And so that's a fundamental importance in the judge's decision and on this appeal, and that will require careful consideration of the claimant's pleaded case and of what particular acts are alleged to be carried out and where by the remaining defendants. And then, having looked at that, there'll need to be consideration of what the alleged damage relied on is, the claim in relation to damage. Those are important both for the purposes of Gateway 21, see whether we pass through that gateway, but also for choice of law under Rome 2, because of direct damage to the central, and indeed...
Sorry, you phrase that as if those are two distinct issues, whereas at the moment it seems to be they're one and the same.
My lord, yes, they give rise to the... It's the same. I'm identifying where they touch on the case, but your lordship is absolutely correct. So, my lord, my lady, I will address the nature of the claimants in my submission this morning. First, address the nature of the claimant's case, and to do so, I will have to take you through the pleadings to show the nature.
No, that's absolutely expected.
Yes, good.
No need to apologise. My
lord, I'm glad. But I'll go first through the nature of the claim as considered by Mr Justice Thompsell, but also in that there is now a further version of the particulars of the claim which reflects those claims that are said to survive following the striking out of the claims against D1 and D2 and D3. It will be important to compare what's said to survive and what the difference is, because there are certain allegations which might have been thought to relate to some form of dealing within the UK, which have been excised.
Well, fine, but why do we need to consider anything other than the latest version? Why can we not just simply concentrate on the current version of the statement of case?
My lord, we could. Of some importance, there are in Malone Friend's skeleton argument. He refers in particular in the relief section to his springboard claim. He says this springboard it must be seen as relating to dealings within the UK. Now, we say that when you see what has been excised between the earlier version and the later version of that, and certain things that have gone, it's very clear that insofar as there was even any peripheral connection that might have been pleaded, those were removed by pleading. So it's...
Well, so be it, but we can see that from the latest version, surely.
My lord, there's no tracking. But your lordship's absolutely right.
The amended document doesn't show the amendments. Well, that's useless. That will have to be sorted out in any event.
Well, my lord, we hope it won't, in that...
Yes, okay. If the case goes forward, I should rephrase myself.
Yes. My lord, yes. But so for that reason, it's easier to go through and...
Well...
my lord, I mean...
I'm sorry, this sounds very unworkable. Because then you mean to say we're going to have to compare the two documents to see what's been excised?
My lord, it's paragraphs that have gone. My lord, yes, but I prepared a note.
I'm deeply unhappy about that.
My lord, I apologise insofar as it's...
all right, well, okay. Well, if that's how it is, that's how it is. But that's what we'll have to do.
My lord, I will attempt to make this painless as possible. But
just to be clear,
my lord, yes.
Are the further amended particulars of claim a draft, or have they actually been amended?
My lord, they have been amended. They have been amended, and permission was given at the consequentials hearing before Mr Justice Thompsell to make that amendment.
Yes, and I can see that, as you told us earlier, the amendments are not shown, which I find shocking.
My lord,
but there we go. It's a flagrant non-compliance with the rules.
My lord, yes. So, my lord, with that What I will endeavour to show you is that although my learned friend Skeleton repeatedly asserts that his complaint in this case, as it now survives, as against D4 and D5, relates to misuse of confidential information within the jurisdiction. In particular, he suggests that he's complaining of downloads, as he puts it, of competing gaming software or access to such software to what he calls punters in the UK, which is my learned friend's analogy of importation of CD-ROMs. That's simply not the case. We say that is not how it's pleaded, and there is no act of misuse in the UK alleged by either the fifth or the fourth defendant, alone or in combination with any other. And just pausing to flag this up, why, because you may say, why are they, if they're so keen on a springboard, why have they not pleaded such a case? Well, because of the particular nature of the confidential information alleged in this case, which is information that's available from inspection of games on a particular website in a very short period of time before they're launched. And as soon as those games were launched by Playtech, all confidential information is gone, and that's how the case is pleaded. Then there is no allegation that any of my clients, in respect of any of the games that are said to have been developed from those games, have dealt in those games before the confidential information was lost. So there could be no allegation of misuse from importation, even on a CD-ROM, or downloading or access by punters in the UK, because by that time there was no confidential information left. So it really is all about the indirect consequences of acts that took place in Latvia.
Sorry, just so I'm clear about that, are you saying that in all cases the games that were viewed pre-launch had been launched by the time any damage is said to have occurred?
My lady, yes. Sorry, I turned around because my gown had got caught and I thought someone was tugging it. It was a ghostly notice. My lady, yes.
There's a timing point here.
There is a timing, and it's a time point that the judge was aware of. You'll see when the judge considers it that one of the games, there are only two games particularised as being so-called derivative games. One, the time period in question was 1 day. 1 day it said that my clients looked at it and then a day later it was launched. So even if they'd been developing like Bilio, they'd have had to have launched it before that point. And then the second one, it's a slightly longer period, it's said to be 29 days, though there is a factual dispute about that, cannot be resolved. But a period of 29 days at the maximum. But on that case, what is alleged to have been misused is some information. It's a peculiar allegation. So that my clients looked at a feature in that game. That feature was new and different, and my clients saw it and decided not to use it. So if they hadn't looked at it, they wouldn't know it existed. So how that's said to have been misused. But in any event, on the timing of those and all of the games, as I'll show you when we look at the pleadings, there are they're only confidential, said to be confidential until their launch, and the launch all happened before these proceedings were issued, and there's no allegation.
That's a useful introduction, but given where we've got to,
yes,
shall we have a look at the documents in question?
My lord, yes. Let me just. So I'm going to do pleadings first. Then I'm going to go to. I'll address you on the law and the relevant law. Then I'll go to the judgment and the grounds of appeal. That's the structure. But I'm starting with the pleadings as it goes. And just to be absolutely clear, and I must keep an eye on the clock. We've split the time between us because I know that the panels rise by 4. So we've got 2¼ hours each. I've got 2 hours this morning, and I'll have a quarter of an hour to reply at the end of the day. So, the pleaded case. So there are 2 relevant pleadings before you, and as I say, I will start with the second. Sorry, there are 3 particulars of claim issue. The first particular claim had 2 different claimants, and the second claim was abandoned by the time the hearing came before.
So we don't need to look at that.
So we don't need to look at that one. Tab 11 is the second version of the particulars of claim. The only tracked part of it is the claim form. and you can see that immediately behind. And so what was removed was the second claimant, and what was inserted was the breach of misuse, was the breach of copyright claim. But then the particulars of claim themselves start at CB 171. Behind tab 11. So this is the claim before the judge. Paragraphs 1 and 2, I'll go through, I'm sorry, it's worth going through, sorry, but I'll tell you which bits have gone as I look at this, if I can. But 1 and 2 address the claimant, identify the claimant. CB 172, paragraphs 3 to 5 concern D1 and D2, who are no longer in the claim. And those are, but it is worth saying, they are identified as, the first defendant is said to be a provider of business-to-business solutions in relation to gaming. They are the entities that are said to be providing these games to the market, whereas D3 and D4 are said to be the entities that are developing games. So again, when it comes to direct acts in the UK, if it's going to be anyone, it wouldn't be D3 or D4, or indeed D5. 6 to 8 introduce the third and fourth defendants. Third defendant is a Maltese company, no longer in the case, can be crossed out. Paragraph 7, the fourth defendant, that's the one that remains, is a Latvian company, and those were referred to compendiously as on air. Now they're just referred to as on air on its own because it's only one of them. And then at paragraph 9, what's said is On Air has at all material times operated as business as an online gambling game design studio and supplier to online gaming operators. The next part of it, in particular, On Air develops content exclusively for Games Global, that's D1 and D2 as were, and further On Air describes itself as Games Global's live casino offering. That has been deleted. But it's certainly the case that was related that my client at D4 is the provides services exclusively of its games to D1 and D2. So if they're not doing anything, it's difficult to see who else would be. And then the fifth defendant is a software developer, and that's, as we've spoken, he was an employee of the second claimant, as was, but he's employed by a group company of Playtech. Then at paragraph 11, the Horizon test environment is introduced. So this is the environment that was accessed said to be accessed by D5 after his departure, and it contains a mix of different games, and then but it said that they're important and they would allow commercially important information to be obtained by people looking at it. And then paragraph 13, we have, during the term of his employment by EuroLive, so that's the second claimant as was, the fifth defendant was granted access to Horizon, and it sets out his access details. That, of course, was all in Latvia. So EuroLive, Latvian company, fifth defendant, Latvian in Latvia, and indeed, when we come on to the fourth defendant, it's all about Latvia. So, paragraph 14 then defines the confidential information. What's said is, by reason of the matter set out at paragraph 12 above, any information available on Horizon that is not at any given point in the public domain is then confidential. So it's excluding from it anything that was later published. And then at 15, we have details given in respect of, it's a particular confidential information relied on. This was not in the first version, but further particulars provided when my clients complained. This is the particular information in relation to, I think it's 9 games that are said to have been, that are relied on as being available on Horizon and which are said to have been accessed by Mr. Veliks. And just looking at them, there are only 2 that are relied on in respect of misuse, but just looking at them, the structure of them is the same for each. At 15A, there's a reference to Quantum All Bets Blackjack, and details of how it would appear and function when released to the public on the 28th of September 2021. So all of them refer to a game and the date it then lost its confidentiality when it was released to the public. So it's a time-sensitive approach. The two games that are relevant to the case as brought, and in respect of which misuse is alleged, are one called The Greatest Card Show, which is at CB 177 behind little f. And this is the details that are relied on. It was launched on the 26th of October 2022, and it's a live dealer entertainment game, and the particularly important point was a horizontal wheel. This is, so F little Roman 1, it said that there was a horizontal wheel that was relied on, and that's the key bit that's been picked up on. And then I, which is on page 178, 8 internal, this is Jet Set Racing Roulette, and this is the one that also had the, we'll see, had a logo in it that's said to have been copied in a screenshot. But the details of how Jet Set Racing Roulette would appear when released to the public on the 8th of March 2023, so not confidential after the 8th of March, and various novel things are said to be about, important about that. And then at 16, so all of those pleadings of the particulars of confidential information are the same in the latest version of the particulars of claim. Subject to that, there is some, there's a tweak to the allegation in relation to access to Horizon, as we'll see, because Horizon, there's said to be a secret part or an important part of Horizon that wasn't accessible to the public, and so that's been tweaked, but the substance of the claim is the same. And then at 16, it said that these matters were confidential, and anyone accessing them would know. At 17, there's the plea of copyright infringement. I'll skip through this quite quickly, just to show you what's relied on in copyright infringement. That's at the top of page 180. That's the logo, Jet Set Racing Roulette. And what's said about that, as we'll see, is that that logo, it's inferred, it's not actually demonstrated, it's inferred that that must have been in a screenshot of the game because the logo appears in the game at various points. But that's the long and the short of it. Then at 18 onwards, this is where it really gets important in my submission. These are the acts complained of. So 18, since the 2nd of August 2021, the fifth defendant has accessed Horizon without the claimant's consent. So that's access in Latvia. And then further, paragraph 19, since at least 11th of November 2021, the fifth defendant has enabled other persons working for and on behalf of On Air, that's all the defendants, but includes a reference to my client D4, to access Horizon. So two different forms of access, or the same form of access, but different people being authorised. And then at 20, further, since at least 11th of November 2021, said other persons working for and on behalf of On Air have accessed Horizon without the claimant's consent, so all about access. And then 21, the fifth defendant and On Air have used the information acquired by their access to Horizons aforesaid without consent. So that's, my clients are not said to be importers or people who make the games available to the public. This is a development allegation. So it's access and development based on these matters. And then at 23, we have some particulars of what's going on here. And the important ones, I'm not going to go through these in detail, but the important ones are at E on the next page. So A to D is reports from others that there had been access. And then at E, the claimant's own investigations. And what we have in the middle of E, little Roman I, is reference to an Annex 3 and an Annex 4. And Annex 4 is the report of every instance of access to the Horizon system by the fifth defendant or On Air, so or the fourth defendant. And then a report of the instances of access to games not yet publicly available at the time of access is provided herewith at Annex 4. So that is a schedule setting out the entirety of the misuse in terms of access. And that can be found, you may have to, if your eyes are like mine, you may have to squint to look at it, but if you go behind page 231 in this same tab, there's Annex 4, and then I apologise, I'm going to have to bend over and peer, but this is a schedule that lists out 33 instances of access, and the two that are, and red under the games heading, it means that's a game that was not yet made public when access was made. So this records time of access, it records the username of the accessor, and you can see it's all Veliks, which are the details of the fifth defendant. It also, there's a country heading, it records the access from which, the country from which access was made. And if you run your eyes down the country heading, it's all Latvia, apart from, I think there's one Poland and two Isle of Man, or Isles of Men, I suppose. But there are two
Look like two Polands.
yes, exactly. But nothing within the United Kingdom. So there's no access within the United Kingdom. And just looking at the two that are relied on as having been copied, because we get onto something called the derived games, are the Greatest Card Show. That's line 25, if you can see, accessed from Latvia. One access on the 25th of October 2022, that's a day before it was launched. And then Jet Set Racing Roulette, there are 5 accesses recorded from the 7th of Feb to the 3rd of March, and it was on sale on the 8th of March, but there's a dispute between the parties that it may have been launched actually on the 8th of February at a trade show, but that's a factual dispute that would have to be dealt with at trial. So we say that's the sum total of the access, and those are all, just to be clear, accessed from Latvia. Nothing in the UK. So the specific ones. Going back to the particulars of claim, at 182, just looking at the specific uses, we were looking at how Annex 4 was introduced, and then F deals with a particular access on the 7th of February, which is how the screenshot was taken, which was access, I think, in Latvia before they came to the UK. And then at 24, we have the allegation. The conduct aforesaid was part of a course of conduct by which the fifth defendant, other employers of On Air and On Air itself, engaged in analysis of a competitor's games prior to their public launch for the purposes of developing competing games for Games Global. So what's said is not that we have launched ourselves D4, D5, certainly not D5, who's an employee of D4, it's development. And I remind my lords, my lady, you that D4 is a Latvian company. This is all going on in Latvia, the development. And then without limitation to the generality of the foregoing, the claimant will rely in particular on the following on-air games which have been developed based on, upon and or otherwise assisted by access to the following games of the claimant. So that's the two we've looked at, Greatest Card Show and Jet Set Racing Roulette. And the derivative games, so-called, are Travel Fever and Diamond Rush Roulette. So we say nothing there in relation to acts in the UK, in relation to my clients. And then at 25, this is the just in case there's a misapprehension about the scale of what's said to be the wrongdoing here, the alleged wrongdoing here, 25 provides the particulars of misuse. So Travel Fever, so pending evidence and disclosure, but Travel Fever uses a horizontal wheel. So the similarity between the games is a horizontal wheel, and that's the game where there was a one-day advantage alleged. And then B, and this is the one the judge understandably had some difficulty working out where this went, but Jet Set Racing Roulette contains a novel feature in which the bonus round is played before the roulette round. The fifth defendant discussed the bonus mechanism with Mr. Ivanovs during their time in London in February 2023 to consider whether this was suitable for Diamond Rush Roulette, and rejected the feature, thereby accelerating the development of the game. Now, just pausing there.
So non-use is misuse.
Well, my lord, not just non-use is misuse. It's non-use of a feature that if we hadn't allegedly looked, we wouldn't have known about it. So in fact, both the cause of and the solution to the problem was looking at that game, because we didn't know this feature existed. So we looked, learned a new feature, allegedly, dismissed it. So it's not, it's an extraordinarily thin claim, is what we would say. But in any event, it's something that cannot have survived, the information cannot have survived the publication of the game by the claimant when they launched, and there is no allegation of any trade in any of the derivative games prior to the launch by the claimants. So there's nothing that is even arguably said to be done by way of download or access or whatever occurred at a time when there was any protectable information in relation to the game that is set to misuse it or not misuse it.
So the claim is speeding up development.
It is. It is. So it's about, and my lady...
to market sooner after the launch of your client's game.
My lady, yes. But that, and this is important because when we come to considering the issue of direct damage for the purposes of Gateway 21 and Rome 2, and indeed considering when one looks at direct damage, one has to ignore the indirect consequences of the act. And when considering, is there an act that's alleged to have happened in the UK? There is no act of misuse that is said to have happened in the UK. And there is no direct consequence in the UK. It's as indirect can be, right, my lady, because it is something where the confidential nature had evaporated by then. And so even if there were a head start, any claim in relation to that damage is not direct damage felt in the UK. It's an indirect consequence point. So we say not even pleaded as such. Then, moving on, the fifth defendant's obligations of confidence are set out in paragraph 26. And 27, the fifth defendant's breach of confidence or trade secret is set out. By reason of the acts about which complaint is made herein, none of which were done with the claimant's consent, the fifth defendant has acted in breach of his obligations of confidence. And then A says necessary quality of confidence, B, the obligation of confidence set out at 26, and then the fifth defendant's acts set out at 23 to 25. So those are the ones that are allegedly breached. So it's tying them into those particular acts we're talking about. So for the fifth defendant, it's only development. There's no allegation of any involvement by the fifth defendant in anything other than game development and providing access. And then 28 reframes the same thing in terms of the trade secrets regulations. Fifth defendant's infringement of copyright, I can skip through other than to say it's said to be importing a screenshot. Again, an artificial claim, but I've not enough time to address it, or waste time addressing it, we would say. And then 35, this is an important point, because this is on air's breach of confidence and trade secret. Again, by reason of the acts about which complaint is made herein, none of which were done with the claimant's consent, on air have acted in breach of their obligations of confidence, and the acts in question are at C, on air's acts as aforesaid. So that's only, it's referring back to those particular points that have been said. There's no allegation, as I pointed out, of any act by on air in this jurisdiction. And then 36, the allegation in relation to the trade secrets. 37, it's said, and we don't, for the purpose of the jurisdiction one, we don't dispute the vicarious liability approach. It's said that the fourth defendants are vicariously liable for the acts of their employee. And then 38, joint tortfeasance. Now, this is a paragraph that has gone completely, but I need to show it to you because it's the closest we come to seeing anything that relates to something happening in the UK. So joint tortfeasance, Games Global, so that's D1, D2 as were, has at all material times and in all material respects acted in combination with On Air to secure or otherwise assist in On Air's design, development and release of online gambling games. Bear in mind the allegation was that On Air was providing games exclusively to Games Global, so they weren't releasing them themselves, it's going to Games Global, and or in such a way as to further those acts in pursuance of a common design, that those acts be done knowing or at least turning a blind eye, and so on and so forth. So again, no allegation there of a particular matter going on in the UK, but there is, if we go through, there's just one point. At B, in the particulars, it's alleged that On Air develops content under the On Air brand exclusively for Games Global, so there's no one else. If it's not Games Global, no one else is dealing with it, on their case. And then at D, I just need to flag this up because it's a game that reappears later. D, by way of example of direction and day-to-day involvement, so this is about the common design, the involvement between Games Global and On Air, there's a reference to creation of the live slots game 9 Pots of Gold, adopting the features of the current well-known live slots game Buffalo Blitz. That 9 slots of gold is not alleged as a misuse of confidential information. Yeah, so it's referred to, but it's not one of the games that
is that well-known tort of producing a competitive article?
My lord, yes. And indeed, we say customer intelligence are looking at their data to see what's there and competing. And it is a fiercely competitive marketplace. I think there's common ground on that. But there are acts in relation to particular games designed by On Air that are said to be presented to UK users as provided by Games Global. That's at CB194K. And I just remind you, it's all gone. It's all gone. And it seems slightly artificial, but the fact that it's gone, it gives the lie, in my submission to my learned friend's claim that it's all about downloads here. And indeed, when we look at what's said about Springboard, it's important.
Sorry, I'm just catching up with you. So I'm at page 194.
K.
So subparagraph K.
Yes.
You say that's gone.
It's all gone. Everything here everything in 38 has gone. Right. But further, games designed by On Air are presented to UK users as provided by Games Global, for example. And here we have 2 allegations of things being presented to UK users as being provided by Games Global. It doesn't say who's actually doing it, but it's just how they're presented. And 2 references to 9 Pots of Gold. And Overleaf at 3, 9 Pots of Gold is referred to. So again, this is the only UK act that's referred to is in relation to a game that was never alleged to be a misuse and is any event in a paragraph that's now gone. Relief. That's the heading rather than suggesting how you should feel. But by reasons of the act complained of, the claimant has suffered loss and damage. And then what is said in the next paragraph is actually how the case was run before the judge below, and it was run at every point until the learned friend's appeal skeleton. By reasons of the fact complained of, the claimant has suffered loss and damage. Being a company registered in the United Kingdom, all such damage is suffered in this jurisdiction, irrespective of the place where acts leading to said damage occurred. And we say that's just not good enough in terms of damage for founding jurisdiction. And then 40, and this is a paragraph that survives in amended form, but I'm going to tell you which bits have gone. So 40 in particular, by its acts in breach of confidence and or unlawful use of a trade secret, On Air was able to launch the derivative games in combination and pursuant to a common design with Games Global and thereby together make them available to the public in the United Kingdom, taking advantage of and knowledge of a number of features of the Claimants game sooner than otherwise it would have been able to. And then that's a springboard. So I think it's probably simplest to show you what's in the amended particulars of claim on this point, because it may short-circuit matter. This is at paragraph 34 of the new particulars, behind the next tab at CB251. And this is a paragraph that's relied on by my learned friend as saying, this is why you should know it's all about downloads and providing games to punters in the UK. So paragraph 34, starting in particular, by its acts of breach of confidence and or unlawful use of a trade secret, On Air was able to develop the derivative games, taking advantage of. So what's happened there is that what's been deleted was On Air was, and then we delete, able to launch the derivative games in combination and pursuant to a common design with Games Global, thereby together making them available to the public in the UK. And it goes straight on to taking advantage of a number of features. So insofar as there was ever an allegation of anything relating to the UK, it's been removed, deleted by amendment. Because, and it's not for me to say what's in the claimant's mind in this, but I would suggest that this is because the only thought they ever had of anyone providing anything in the UK was one of the other defendants who are now gone. And in any event, the actual supply of games in the UK could never be a misuse of confidential information itself, because all of the information that they rely on as confidential is no longer confidential at that time. So there simply is no case in relation to the exploitation of games developed. There are cases in relation to development and access, and that's all the stuff that happened in Latvia. So, that really is the nature of the case. And we say there's not a hint within there, even in its unamended form, of anything that could give rise to a claim of direct damage in the UK, let alone any act in the UK itself. And the deletion of the matters I've shown you, paragraph 38, that passage from that paragraph we've just been looking at, makes it absolutely clear that insofar there were ever any hint or whisper of such a case, it went because the judge held it wasn't arguable in relation to any other defendant. And no cross-appeal, no respondent's notice. So, my lords, my lady, I can take you through the changes in the amended particulars of claim and show that there's a reference to a locked part of Horizon rather than all of Horizon, and there's a tweaking of the game to try to and just flag that up. But the key points are the ones that I've shown you. I'm in your hands. It will take.
But if it's the key points, then
I
does it sound like we need to look in your...
There's no, so those points have been, any reference to D1 and D2 has been excised from the amended particulars of claim, and any reference to any act that even purported to connect D4 with matters in the UK has gone, and there was never any connection in relation to the UK, between the UK and D5. Because bear in mind, I have two separate clients here. There's the individual, Mr Veliks, who's been hauled into this claim, and then D4. So with that introduction, I just show you how Malone Friend characterises this case in his skeleton argument, and say that it's absolutely not how it's pleaded, but I agree with him that it is essential, as he says in his skeleton argument, that the court consider carefully the acts, and if he can't establish acts giving rise to direct damage, acts in relation to downloading or provision to punters in the UK, then his case is hopeless. But let me just show you where he makes these points in his skeleton before I come on to the law, because in my submission, the suggestion that his case, as against the client still in, relates to provision of games in the UK is something that's just been cooked up on appeal. So, Malone Friend's skeleton argument makes clear at paragraph 5, so this is behind tab 5, page 2 of the skeleton, CV 51. It says more specifically, the claim focuses specifically in the relief it seeks on this springboard effect. The unauthorised access to Horizon platform and the internal use of information hosted there to develop competing games is an important part of the picture. We say that's the only thing that relates to my clients. They are said to be unlawful in themselves, but the acts directly causing the damage that the claim focuses on are the actual provision of competing games to punters. And then what's said in I mean, it's all about, so again, at 8 and 9, Malone Friend characterises our case as being saying, well, judge this by Latvian law, and somehow that will avoid any effect in relation to an alleged wrong in this jurisdiction. But again, he's spoken about 9 in support of that. He says, Realtime contends for the startling result that some other law determines whether acts directly causing loss in the UK market amount to unfair competition. My lords, my lady, that's not our case. We just say the pleaded case doesn't relate to acts directly causing loss in the UK market. Not only is it a startling result, but it's also contrary to the international regime that determines those matters, Rome 2. We say Rome 2 does apply, but it applies in directly the opposite way to what my friend says it does. There is no direct loss in the claim. That provides that one looks at the place where the damage is suffered to determine the governing law. The damage here is fewer uses, fewer downloads. There's no download as part of the claim of Playtech's games. That damage has nothing whatever to do with Latvia. And so we endorse Malone and Friends' analysis at 13, saying it's important to keep clearly in mind the following different concepts. The distinct claims they've chosen to bring, I've shown you those, all to do with access and development, nothing to do with the downloads. The national law governing each specific claim, again we'll say that that's Latvian, whether the court has jurisdiction for the specific claim, and whether the court should. So we agree with that principle, but we disagree with Malone and Friends' contention at 16 that it's key to understand that the claimant seeks to bring claims in respect of the provision of software products. That's simply not what particulars of claim show. And that, in fact, given Malone and Friends' acceptance that that's the important point, really is the end of the matter. And the judge lost sight of that. We'll see when it comes to appeal. He lost sight of the need to consider direct damage, and he seems to have been confused as to how, what acts were in issue, and whether there was any direct loss, the importance of whether there was direct loss in the UK. So, the law, the general principles I hope I can deal with briefly. They're very well known, I know, to the panel. And I could take from my skeleton paragraph 28, which is tab 4, page 35. So there are 2 different areas of law that are around. There's the matter specifically to do with choice of law, Gateway 21, and in particular Lord Justice Arnold's decision in Selgard and how that feeds in and related jurisprudence. But there's also the general principle as set out in Ultimo Holdings. It is for the claimant to satisfy the courts of the burdens on the claimant, but in all circumstances, England and Wales is clearly or distinctly the appropriate forum. There are 3, it's well, I can take you to the authority, but I hope I don't have to. There are 3 aspects. So first, a clearly article case of real conviction. Second, that case slide through one of the gateways. And third, the question of forum discretion. Again, the very well-known passage from the Vedanta case and the summary of Erster and Red October saying stand back and ask the practical question. The only point of slightly more detail is if we get on to consideration of forum conveniens, there is a point that we say the judge fell into a separate and distinct error concerning the weight he gave to what he perceived to be a procedural advantage in relation to disclosure or discovery here as opposed to in Latvia. We say he gave it the wrong emphasis. He shouldn't have given it the weight he gave. We get that, that's plain from Spiliada, but to be absolutely clear, if I'm arguing about that, although it's a good point and it's an error the judge fell into, I've lost on a number of other things that are pretty fundamental to the case. And in my submission, the key point, the key error the judge fell into was direct damage, failure to realise that there was no pleaded direct damage, no argument of direct damage in the UK, and application of the wrong law. So, that brings me, bearing in mind the time, to the central issue in the case, which is the distinction to be drawn between direct damage and the indirect consequences of an alleged unlawful act for the purposes of the choice of law under Rome 2 and obviously the gateways on jurisdiction. I put in my note, these are closely intertwined. I accept Lord Justice Arnold's point, they're essentially the same point. But it's worth, before starting on this, of course, applicable law is not only fundamental to the gateways, it's also very relevant when we come to the forum analysis, because if we're correct that the correct applicable law is not English law, it is in fact Latvian law, it's a very strong connecting factor, along with everything else, to say this case should proceed in Latvia. The relevant gateways, before we come on to look at that, the relevant gateways considered by the judge were Gateway 2, so that's, should there be an injunction, is there an injunction claimed in the UK, Gateway 9, which is the tort gateway, and Gateway 21. I don't know whether it would be valuable just to look at those in the white book to remind you of the
I don't think we need to do that, because it's not about the gateways, and you already made the point that Gateway 9 is wrong anyway.
My Lord, yes.
Which is common ground. The relevant one is 21.
My Lord, yes. Though when we come to the judgment, the analysis, the heavy lifting of the analysis in respect of cell guard and direct damage and indirect damage is all done in the context of 9, but then he reapplies it.
Well, exactly. So it's an error, but it's an immaterial.
My Lord, yes. Gateway, and as we'll see, Gateway 2, the judge held they didn't pass through the injunction gateway because he saw there's no prospect. There is a slight oddity there in that he later gave permission for the amendments, as we've seen, which claim a springboard injunction. But again, I'm not sure anything particularly turns on that. I'm not saying that's a thing. It's a tension. But we'll see. He had a pretty clear-sighted view of how minor the minor nature of the unlawful acts that were actually pleaded were, and there's a lot of talk of just scraping over, particularly scraping through a threshold or just making good one point. But in doing so, his real error was the choice of law point. He fell into error in identifying the correct choice of law. So, choice of law, Rome 2, the relevant provisions are in the authorities bundle.
Well, you set those out at the beginning, your skills argument, if we've got it open. So there's no dispute that this is unfair competition, therefore prima facie Article 6. However, it's a single competitor, therefore Article 4, and you've set out Article 4.
My Lord, yes. Then I shall not go to Rome 2. What I would say, just looking at Article 4.1, and it's a point that I may have made already, but I shall bang the drum again. Article 4.1, unless otherwise provided for in this regulation, the law applicable to a non-contractual obligation arising out of a tort delict, so confidential information because of 6.2, shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences of that event occur. And it's all about direct damage, and we say my learned friend's case, as presently formulated, indeed as ever formulated, is all about indirect consequences of the event, not about direct damage. But, lest we lose sight, this is a point that the judge did not consider in his judgment. Article 4.3, Rome 4, provides an escape clause. So even if we were wrong, or in some way the judge, the claimant scrapes through in relation to some form of direct damage in the UK, we say we are entitled to rely on the escape clause, which is where it is clear from all the circumstances of the case that the tort delict is manifestly more closely connected with a country other than that indicated in paragraphs 1 or 2, the law of that country other country shall apply. A manifestly closer connection with another country might be based in particular on a pre-existing relationship between the parties, such as a contract, that is closely connected with the tort delict in question. So we, before the judge below, we argued that even if they scrape through on direct damage, it was all about Latvia. The previous employment between Mr Veliks and what was the second claimant before they removed the second claimant, which was governed by an exclusive jurisdiction clause, is which designated Latvia. All of the development that is said to give rise to this later loss took place in Latvia. Everything we say connected us really is the surrounding circumstances all about Latvia, even if we're wrong on direct damage. So we say the judge fell into error by not considering at all that point, which allows the court to be able to revisit it, though we say he fell into other errors before then because he didn't properly characterise the damage or consider the damage as being the question of whether the damage alleged in the pleading was direct damage. So, interpretation of Article 4. Before we get to Selgard on the point, I just want to show you the summary in Dicey and Morris behind tab 3 in the authorities bundle. This is a tab 3. At page 23, JA 23, paragraph 35A24. Now this is within Article, the Article 4.1 analysis, and sets out, although this analysis is repeated and indeed references to Selgard are repeated in the intellectual property section and various others, this is a convenient place to look at it. Article 4.1 requires, as a general proposition, application of the law of the country in which the damage occurs. For these purposes, damage includes damages that is likely to occur, fair enough. The law of the place of damage applies irrespective of the country in which the event giving rise to the damage occurred, and irrespective of the country or countries in which the indirect consequences of that event occur. The general principle therefore focuses on the place or places where direct damage is suffered by the claimant and ignores the fact that indirect damage may be suffered by the claimant elsewhere. 145, and that is a reference to Selgard and Shenzhen, which we say is the leading case on the point, and we'll go to that now. Yes, I don't necessarily need to go to other points. So Selgard is at tab 14 behind the joint authorities bundle. Lord Justice Arnold is plainly very familiar with the subject matter of this, but I just flag up or orientate the panel generally with the idea of what was in dispute, the different classes of damage. From the head note at H3, there's a useful summary of the two types of claim advanced by Selgard, the claimant, based on misuse of its confidential information, namely direct claims against Senior for offering in the UK battery separators that benefited significantly from the alleged unlawful use, and then second, vicarious claims against Senior in respect of the alleged breaches of confidence by Dr. Zhang. Now, it's called a vicarious claim because the Act itself was a direct claim, it's a direct claim of access, but the nature of the liability was as an employer of Dr. Zhang, who was not a defendant. So that's why it's referred to as the vicarious claim. There's no magic in the term particularly, but that's how it came in. Obviously, in this case, we have...
Well, I'm sorry, there is magic in the term.
My lord, I apologise.
Because it's a correct description of the legal theory that's relied upon.
My lord, there is a... The reason...
It's vicarious liability for the acts of an employee.
My lord, yes. My lord, you're absolutely right. I overstep the mark in saying that, but it's when... when we come to the judgment, there are hints, at least, that the judge may have, by referring to the vicarious claim in Selgard and bearing in mind that vicarious liability in respect of some of the acts is what's relied on here, there may be some confusion that crept in, so I was trying to avoid that. But you're absolutely right. wrong for me to say that there's no magic, there's law in it. But crucially, what was alleged in Selgard, and we'll come on to look at the case, was that importation of these battery separators was itself a misuse. Now, it may be derived from the sort of original misuse, the accessing of the information by Dr. Zhang in China, but then that confidential information was embodied within the battery separators and was still protectable. There were disputes as to whether, so there's a very important distinction between the facts of the present case, where if one views the software and the games here as being akin to the battery separators, there was nothing protectable in them. They were the indirect consequence, the fruits of an alleged misuse. They weren't themselves, even if there were an allegation of importation, of downloading provision to punters in the UK, which there isn't, but even if there were, it would be an indirect claim. It's not like supplying a battery separator. Having briefly looked at the headnote 13 addresses what the issues were on appeal, just to short circuit this slightly. So there were disputes as to whether the information had been properly particularised, but then at H14, one of the central and most important from our perspective disputes on appeal was the argument that Senior argued that confidential information was intangible property. Damage to intangible property was located at the time and place. It became irreversible. That being so, the judge had erred in law and should have concluded the applicable law was Chinese law. That's not correct. The principle articulated is not correct. Senior also argued that when seeking to determine whether the acquisition of a trade secret was unlawful for the purposes of 4.5 of the Trade Secrets Directive, 4.5 doesn't really feature greatly in the way this case has been pleaded, it was the law of the place where the secret had been acquired, here China, which applied. Now that ties in a little bit to the Lord Justice Arnold referred to a footnote in the later version of Dicey and Morrison, and I'll address you on that, but our primary position is it's just not relevant here because of the way the case is pleaded. And so arguments about what was the applicable choice of law. And so we pick that up on appeal at JA 399, paragraph 50, under the heading Applicable Law. So at 50, sets out. Rather than reading this all out to you, and those of you, could I ask you to read down to paragraph 55, which is where we get to Selgard's case on Article 4.1. I don't know, I don't wish to hurry anyone on. Are you ready? Excellent, sorry. Within that, 2 points just quickly to draw out. Paragraph 53, there's a reference to the exception under Article 4.3. Didn't apply in that case. Does apply in this case, as I said. The judge didn't consider it, so that's 1 point of difference. But the case as set out, Selgard's case, as set out Article 4.1, was accepted by the judge below and then is considered in Lord Justice Arnold's decision from 57 onwards, addressing a number of arguments that are advanced by Senior's counsel as to why that position in relation to direct damage should not apply. Indeed, the upshot is that the key distinction is between direct damage as opposed to indirect damage. There are a couple of points in particular that are of importance within the analysis and the rejection of Senior's case, and in particular paragraph 62 under fifthly. Fifthly, the act of, so this is on page 401, the act of unfair competition, which is the subject of Selgaard's direct claim, is the importation into and marketing in the UK of infringing goods, as defined in Regulation 2, Art 2 of the Trade Secrets Directive. That is the market which is affected by that act of unfair competition, and that is where direct damage is sustained. The fact that the infringing goods were manufactured in China is immaterial. I accept that, as Counsel for Senior pointed out, this analysis does not apply to the vicarious claim, so that's the accessing in China claim. In itself, I do not consider that this matters, given that the direct claim is the main claim, but this point is connected with the point concerning Article 4.5 of the Trade Secrets Directive considered below. Just pausing there, we accept, and as must be, that the legal principle governing whether or not damage is relevant is the difference between direct and indirect damage. And if there were a case that were pleaded out here in respect of importation and marketing in the UK by any of my clients, then that is something that would give rise to a consideration of direct damage, because that's what would be alleged here. But my learned friend's approach in his skeleton, which is to say we argue the contrary, is simply a straw man. It's never been our case that this is not the test. Our case is that the test is not satisfied because the pleaded case doesn't come close to alleging direct damage in the UK. Now, that's what my learned friend would consider to be the direct claim, the provision to punters, which is not part of his claim at all. In terms of the access by Mr. Veliks in Latvia, all of the pointers, in terms of, so this would be the consideration of the vicarious claim.
Sorry. Shall we finish on the law?
My lord, yes, sorry, I got excited. So moving on then to Article 4.5, which is the point that so sixthly refers to the Kai technology case, and endorses the distinction between direct and indirect damage, which Lord Justice Evans drew, and identifies it as the same distinction that applies in the context of Article 4 of the Rome II regulation. And again draws this distinction between the counterexample in Kai technology of importation in the UK of products manufactured elsewhere by misusing confidential information. Again, not the case here. Seventhly, there's a suggestion, this is a point that you will see in my learned friend's skeleton. As Counsel for Selgaard pointed out, the effect of Senior's argument is that where Party A is based in country X, which has weak trade secrets protection, misuses Party B's trade secrets to manufacture goods and then puts the goods on the market in an EU country, the law of country X would apply to the exclusion of the law of the EU country. As Counsel for Selgaard submitted, this is an improbable result given that the Trade Secrets Directive is designed to strengthen protection against misuse of trade secrets, whether from within or from outside the Union, Site 4, and that it expressly contemplates the measures should be granted, which include prohibition of the importation of infringing goods into the Union, Recital 28. Admittedly, Rome II regulation and the Trade Secrets Directive are different pieces of legislation. It seems unlikely that one should be interpreted a way that undermines the objectives of the other, unless that is mandated by the wording, which is not the case. Now, that's a specific point on the Trade Secrets Directive, but we don't dispute in relation to a pleaded act of importation that there is the doctrine of direct damage would apply. Our case is that that's not what goes on here. Now, there is in the later edition, or the supplementary edition of
yeah, well, before we get on to that, can we be clear as to what your position is? Because analytically, the structure of the reasoning in Selgaard is that subject to the impact of the Trade Secrets Directive, counsel for seniors submission is rejected. So the analysis dependent upon confidential information being intangible property,
Yes.
which is misappropriated, and you focus upon the time and place of the misappropriation, is rejected. And then the question comes, well, what about Article 4.5
My Lord,
of
yes.
the Trade Secrets Directive?
My Lord, yes.
So would you agree with what I've said so far?
Yes, my Lord. And we don't, as may have become clear from my submission, my focus on the pleading, our position is very much that the reason...
So you rely upon that. Now, to what extent do you say that that first part of the reasoning is ratio that's binding upon this court?
Well, my Lord, we say that it is. I'm relieved I can say this, and it doesn't affect my case, because although although the judge didn't really differentiate between confidential
That's a
information.
separate question, Mr. Mees.
My Lord,
At this
yes.
stage, I'm trying to establish what
Okay.
your position is
My
as
Lord,
to the law
we accept that-
and as to the impact of the decision in Selgard.
My Lord, we accept that it is part of the it's part of the ratio of Selgard, and it is binding.
You might be going further than accepting. I think you're positively arguing it, aren't you?
Well, my Lord, we're endorsing because of the way we say that but whether the fact that I'm not whether I endorse it or, as opposed to merely accepting it is just it's a matter of the facts of the case. In my submission, it's the law as set out there, and that's what we have to deal with.
Sorry,
Can I be sure I understand what it is?
My Lord, just sorry, I beg your pardon.
What do you mean by it? It is part of the ratio. What is part of the
So
ratio?
the finding that absent the effect of any contravailing effect of the Trade Secrets
Yes.
Directive, the approach in relation to the importance of differentiating direct damage and indirect damage is the fundamental determining question, subject to any escape clause under the other parts of Rome 2, Article 4, so 4.3. That is the approach to be taken in relation to confidential information cases. And we also, although there is given there are, yes, so I don't need to
Yes,
further.
and
so I
you've
accept
already
that.
told us that your submission is that Article 4.5 of the Trade Secret Directive is inapplicable in our case. And therefore, as I understand it, your position is that we are bound by the reasoning, if that's right, we're bound by the reasoning in Selgard.
My Lord, yes. Why I pause and say yes on that is if my learned friend resurrects or persuades you that there is some case that falls within Article 4.5, which we say that it's not pleaded. That's our fundamental point on this appeal. There's nothing that 4.5 is an apposite. It's not that doesn't fit within his claim. Then I would be arguing about that aspect of the case, but I don't see that bleeds across in relation to the misuse of confidence as opposed to trade secrets.
Well, are you suggesting there's a distinction there?
Well,
the point about Article 4.5 in Selgard was it was a case of, as you pointed out, a case of importation of goods.
my Lord, yes.
Now, Article 4.5 is about importation of goods, among other things. So that's why it came in. But I mean, so far as there's no material distinction either in Selgard or in this case between confidential information on the one hand and trade secrets on the other hand, is there?
My Lord, no.
We are talking about a species of confidential information which is said to amount to a trade secret.
My Lord, yes.
That's true in both cases.
Yes, and indeed the trade secrets, the regulations concerning trade secrets are expressly tied into, in terms of the infringements in trade secrets cases. There's that peculiar wording that ties it into misuse of confidence. And sorry, my Lord,
What?
the things are defined in the same
You're
term.
making something complicated which is not complicated.
I
The
apologise.
directive has to be agnostic as to the legal regime applicable because trade secrets are protected in different ways
My lord,
in
yes.
different member states.
My lord, yes.
So the fact that we treat it as equitable breach of confidence doesn't matter.
My lord, no. No, and certainly not in this case. No. So, Selguard then, in Selguard, you then went on to consider issues arising in relation to 4.5 and characterise it rightly as potentially a difficult issue of law. That's the matter that has been addressed in the footnote to the later edition of.
Yeah, well, your position
but my
is that's
position
all
doesn't
irrelevant.
matter. My lord, yes, that's it, and I'm happy to address you.
Well, there's no point until Mr. Spake makes it relevant.
Well, my lord, then I may move on.
Just before you move on, where do we find the text of 4.5?
So it's set out in Selguard. It's probably the easiest place to find it.
That's 390.
It's page 392.
Is at the top of 393? Thank you.
And the discussion of that point in Selguard, where is,
So that's the discussion point in
where's the
Selguard.
passage you're moving over?
It starts at 66.
Thank you.
Towards 65 and 66. So the importation. So the question of whether there's because importation 4.5
No,
concerns
it's fine,
infringing
I just
goods.
wanted to be pointed to the passage. Didn't want to waste time.
So, there's one further point. My lords and my lady, I think that's all I need from Selguard in light of the way the case is pleaded. There's one further point, which is what comes from AMT Futures and Marzilla. So this is the point that was run by the claimant below. It's not how they run their case on appeal, as I see it. Was the argument, we've seen that in the pleading, that because the claimant is based here, any harm they suffer is harm here, and that would then suffice for the purposes of founding a jurisdiction and for the choice of law.
That can't be right.
It's not right. And I could check. And AMT Future Marzilla puts it in terms that it's not there, and that it's referred to at the footnote to paragraph 53 of our skeleton. But it's so insofar as. But just to be clear, my lords, my lady, that is absolutely how the case was advanced, how it was addressed in Mr. Carrott's evidence in support of resisting our applications to set aside Service Act, all the way through. The question of damage was addressed on the basis of, well, it's an English company, so any harm is harm to us in the UK. So there's not been a whisper of a case in relation to true direct loss. There wasn't a whisper before the judge. I can.
Yeah, well, you've made your position clear on that.
Okay. And then finally, the Article 4.3 of Rome 2, the escape clause. This is addressed in Pickard and Marshall. So this is, if I'm wrong on Article 4.1, this was we say Article 4.3 would nonetheless apply because of the close connection of everything else in this case with Latvia. Pickard and Marshall was, it's a reasoned decision refusing permission to appeal. It has to be viewed in that context. It concerned a dispute in relation to a road traffic accident that took place in France, and there was reliance placed on Article 4.3, and that's addressed in the context of that claim. So at JA 297, paragraph 8, we can see the reference turning Article 4.3, Gentleman's J rejected the view of some textbook writers not argued for by the parties in the case when French law is the governing law pursuant to Article 4.1, but excluded from the part of claims under Article 4.2. It could not be brought in again under 4.3, so he starts considering 4.3 there. And then the key point that we rely on is at 13 onwards, a submission in relation to Article 4.3. As to Article 4.3, Mr. Weir submitted that as an exception to Articles 4.1 and 4.2, it must be read restrictively so as to reduce uncertainty and to enhance predictability. In his submission, to ensure consistency with Article 4.1, the word tort must be construed narrowly to apply only to the claims of direct and indirect victims of the specific tortfeasor. The reference to all the circumstances of the case is to the circumstances of the case brought by the victims against a given tortfeasor. This interpretation furthered certainty, he submitted, since otherwise it would be difficult to limit the circumstances to which reference could be made. So, just to put this in context, what we're angling at here is that although my learned friend has picked a claimant that is not a Latvian company and has now stepped back from his initial reliance on an employment contract as imposing duties of confidentiality, which had an exclusive jurisdiction clause connecting the claim against D5 to Latvia, we say the court should look at the entirety of the circumstance of the case, not just the specific pleaded points when it's considering the escape clause under 4.3. And at paragraph 14, that the submission that the contrary submission that should be that you only look at the circumstances relevant to the specific tort pleaded was considered at 14 onwards. So the starting point in considering these submissions must be the words of the regulation, in particular Article 4.3, demands that attention be given to all the circumstances of the case to determine if the tort delict is manifestly more closely connected with the country other than that which is pinpointed by the application of Articles 4.1 and 4.2. To my mind, the phrase all the circumstances of the case points precisely that, all the circumstances surrounding the tort. Those circumstances are not limited by Article 4.3 by Article 3 by a phrase such as brought against the tortfeasor. Certainly all parts of Article 4.3 must be read together, but Article 4.3 is focused on the law of the country with which the tort delict is manifestly more closely connected. Consequently, it's not on all fours with Articles 4.1 and 4.2, which are concerned with the law applicable to a non-contractual obligation arising out of a tort. Tort can refer to the road traffic accident in this context, just as readily as it can to the cause of action, to use the English approach in applying between the particular victim and particular tortfeasor. That tort is part of a multi-party accident, may be highly relevant to the country with which it is manifestly more closely connected. And then at 16, as to the example in the last sentence of Article 4.3 of a pre-existing relationship between the parties, it is to my mind but an example of the circumstances which may bear on identifying the country with the most manifest connection. Finally, Article 4.3 is an escape clause, but in my view that does not mean its ambit should be unduly narrowed. After all, Article 4.3 is part of a general rule. Article 4 designed choice of law in tort cases where the specific provisions of Article 5.1, 12, Articles 5 to 12 do not apply. So, my lords, my lady, we endorse that reasoning, and it's when considering Article 4.3, the correct approach, we say, is to look at the entirety of the circumstances of the case, not just the specific claim that is relied on. So in a case such as this, where, assume against me, my learned friend has got his direct damage claim off the ground, that there is a claim in relation to the notional electronic importation or provision to punters of games in the UK, then because he has selected that claim out of a possible universe of other confidential information claims, which include the development which took place in Latvia, the accessing which took place in Latvia, it is wrong and artificial and not the correct approach for the purposes of Article 4.3 to disregard those other claims that he could have brought but didn't in relation to that. One looks at the entirety, all of the circumstances of the case. So one cannot, there's a good reason for this, one cannot, through carefully crafting a case that is limited in its specific claim to something that would apply in the UK and excludes matters in relation to Latvia, one couldn't avoid the aim of the escape clause, which is where there is a proper connection, a manifestly close connection with all the circumstances of the case, that could be ducked by just picking the one bullet you're going to fire in your attack. In summary, it's not a high threshold. It requires consideration of all the, not just the individual matters of claim, but all the surrounding circumstances. And we say it will be relevant here because of the nature of the employment and all of the circumstances tying it to that. So, turning now to the judgment. It will be no surprise to you, my lords, my lady, that I am. It's our position that the judge simply got it wrong when he held that the claim passed through Gateway 21 on the basis that was set out in Gateway 9. But there are a number of particular errors we'll identify as we go through. But it's worth just looking at the judgment and seeing how it all comes together. We can skim through some of the earlier parts of it. He starts off with introducing the parties, and at paragraph 8, where he refers...
We've all read the judgment,
well,
so I don't think you need to take us through it systematically. Why don't you just focus on the bits that you're complaining about?
I will, but my lord, there are a couple of points that are important in relation to the nature of the claim. So at paragraph 31, so this is where the judge is considering the access to the Horizon platform. And he says, on the basis of the evidence before the court at the moment, I consider that any information that was on the Horizon platform to which general users could have access should be regarded as information in the public domain. So this is making good the point that there are general users from the public and there were what was called a super user. Whilst there is password protection, it's by no means clear that this of itself was there to protect the confidentiality of the platform. There was anyway a need to protect the confidential details provided by the platform user on the site. It appears that members of the general public are nevertheless able to access such games without any meaningful pre-qualification other than confirming they're 18 years old. The games I regard as being in the public domain include any game that was about to launch where general users were able to access that game. This may be a slightly wider category of games than the games that had already been launched and were in the public domain by that means. So it's a complete mix-up on this Horizon platform, but the judge did hold that there were some games and a case of the threshold being crossed to say that there were some games that were confidential before their launch. We see that in 32. However, I consider on the basis of the pleadings and the evidence provided to me by the claimant that there is a good arguable case with suitable degree of conviction that the parts of the website where access was restricted through settings made by the platform administrator behind the scenes comprise confidential information. Where a game was under development and not available to the public, the information concerning the features of the game can fairly be said of a confidential nature. And then at 33, he addresses what I showed you in relation to Annex 4 of the particulars of claim. And at the final sentence of 33, referring to the games accessed by Mr Veliks, games he accessed and which are listed as being non-public are shown in red in Annex 4 of the amended particulars of claim. It seems the access to these non-public games amounted to only some 33 of the 800 instances of accesses complained of and involved only 9 games. So that's the nature of the case that he was looking at there. He then, just moving through, the copyright claim, I'll just deal with how he addressed the copyright claim. It starts at 44 and his conclusion is at 50. So this is the copyright logo in the screenshot. At 50, he said, in my view, this allegation just about scrapes through on the Kawasaki test. Playtech has put forward a cogent case, and there is an evidential basis for it that, in my view, carries the appropriate degree of conviction. Whilst there's also an evidential basis for a defence against this, the court could not determine the merits. So copyright scrapes through, but it's not really only just, is what we say, but we'll come on to that. Then vicarious liability of real-time Latvia is addressed at 51, and then he considers at 52 onwards the claims against real-time Latvia and real-time Malta. Now, this starts off with consideration of the knowledge that real-time Latvia or Malta had of the activities of Mr. Veliks. So he's saying that needs to be knowledge. And so that goes through to 50. It goes on to about 64. So this is dealing with what knowledge there was. And then at 65, he addresses the specific use that's alleged. And he says, as to specific use being made of confidential information, pending evidence and disclosure, the claimant has identified only 2 games which it says the real-time companies developed using confidential information in the form of features of Playtech games that have been accessed on the Horizon platform at a point when these were still confidential. So we're looking at that. Then he deals first with the Travel Fever game, and he addresses the fact that that's a 1 day, an acceleration of 1 day. But again, it's all about development. It's not about launch. He's making no finding here in relation to any allegation or any arguable case in relation to provision of that game at a time when anything in it was confidential in the sense of what we would say is necessary for direct damage in the UK. And then at 67, he addresses Diamond Rush Roulette and Jet Set Racing Roulette. And it's worth looking at this in some detail. It said that On-Air's game Diamond Rush Roulette was developed with knowledge of a novel feature in Playtech's game Jet Set Racing Roulette, and that this feature was discussed by Mr. Veliks and Mr. Ivanos during their time in London, but they rejected using the feature. Playtech argues that knowing of this feature, so that it could be rejected, accelerated the development of Real-Time's game, but I find the logic of this difficult to follow. I don't say the judge fell into error there. It's extremely difficult to follow. If the Real-Time companies were not aware at all of this feature, they would not have spent any time discussing it. In any case, the springboard advantage, again, is minimal. The first access to the game undertaking using Mr. Veliks' user credentials was made only 29 days before the public launch of this game. And then at 68, he summarises and says there's a number of weaknesses in the case put forward against the real-time companies based on primary liability for breach of confidence through misusing confidential information. So within that, there is no, stress this again, there is no finding of any arguable case in relation to provision of software within the UK. The thing that is necessary for direct damage. And so he says they scrape over and there's enough to get through, well, their case is arguable enough in relation to misuse of confidential information, but it's all to do with development, and it's all to do with the access in relation to the vicarious liability for access by Mr. Veliks. And he makes no finding in relation to anything that could be direct damage. And then just before we move on from the real-time analysis, at 76 he addresses the copyright claim. As regards the copyright claim, if this is made out against Mr. Veliks, I consider that real-time Latvia would have vicarious liability for the claim. I do not, however, see any basis on which real-time Malta would be responsible for the infringement alleged. Accordingly, I consider the Kawasaki test is passed in relation to real-time Latvia, but not real-time Malta. So again, the copyright, he said, if you're through, then D4 would be vicariously liable in relation to that. Then 77, we can skip over this, are the claims against the Games Global Company, which is history. But before we just his finding in relation to the relationship between the two, I think I would submit is important. To paragraph 78, so he's addressing the points that were then abandoned in the particulars of claim, but he says the points made in the amended particulars of claim with support from evidence certainly go to demonstrate that the real-time companies and the games global companies cooperate closely and have particular roles within a supply chain. Essentially, real-time operates as the manufacturer and Games Global operates as a wholesale distributor. They also show Games Global directs game development at a strategic level and offers technical support related to the technology platform, quality control and certification. So that division of labour reveals the judge was not considering, or on the evidence for he held, that there was no, it wasn't D4 who was marketing or distributing the games. If it was anyone, it would have been Games Global, and Games Global are not him. With that in mind, let's address the gateways and see how the judge addresses the gateways. So that's section 8 at CB 88. So we don't say he approached, the law is correct in terms of his, the standard that must be applied. Gateway 2, he says, Playtech has not established any good arguable case that it's likely to be able to persuade a court to grant an injunction. No serious prospect of a repeat of the facts on which the breach of confidence and trade secrets claims are made, since Playtech must by now have withdrawn the login credentials on which Veliks was relying, and any of the information that was confidential when accessed, and where Playtech has been able to allege an arguable case for breach, will by now be in the public domain anyway. Accordingly, I do not consider this gateway will apply. Now, obviously, he then goes on to consider the springboard matter when permission was sought to keep that in on amendment. But that reasoning, again, reveals that any consideration of importation, there wasn't any pleaded, would have been completely hopeless, because by the time such an act took place, there was no confidence left. There's no obligation of confidentiality in relation to any of the material that was relied on as being confidential. Gateway 9. Now, this is his reasoning that it applies in 21. 97, he says, the claim for copyright clearly passes through the gateway, and I agree. I mean, I'm not entirely sure why, it doesn't matter, but in that, yes, it might relate to the property one, but copyright infringement passes through. He agrees, although I strongly doubt whether, if there's no other argument connecting the other claims within the jurisdiction and the other claims are being pursued, the court would accept jurisdiction as regards the other claims merely because of this, given the trifling nature of the breach. You say that's, again, it would be wrong, if we're right about confidential information and trade secrets, it would be wrong for the copyright claim to proceed here. And then as regards the remaining claims, those concerning breach of confidence or breach of trade secrets, it's arguable whether the claims result from acts committed within the jurisdiction. My lords, my lady, we say that is an absolute howler on the part of the judge, because it's not arguable that they result from any act within the jurisdiction, because there is no pleaded case in relation to that. And his findings, early, his factual findings, provide no support for that. So he's starting off in the wrong place, because he hasn't remembered the nature of the case in front of him. He hasn't considered the need to show an act that gives rise to direct damage. And there's a slightly peculiar history to this, because when a draft judgment came out, the Rome 2 choice of law matters were not addressed at all, and so this was sort of parachuted in, and this is where he's addressed it now. So insofar as it reads a little bit disjointedly, it's a result of us pointing out that this hadn't been addressed, but nonetheless, when he addresses Rome 2, we say that he fails to have regard to the nature of the direct damage that is need to be shown, and the absence of any pleading on that point. So, 99. The third and fourth defendants make the point that in a claim for breach of confidence, the applicable law is determined.
We don't need to read it. This is just reciting the law.
So he goes through. So I will move on. You'll write me. So he addresses Article 4, he sets out a reasonable summary of your lordship's approach in cell guard, and at 104, he addresses this. He says, 104, Lord Justice Arnold held at paragraph 62 that since the act of unfair competition that was the subject of the direct claim was the importation into and marketing in the UK of the infringing goods, it followed that the UK was the market affected by that act of unfair competition, and the country where the direct damage was sustained. Absolutely right. Thus, the applicable law for the direct claim was English law. In contrast, Lord Justice Arnold held at 868 that the applicable law for the vicarious claim was Chinese law because the direct damage caused by Dr. Zhang's disclosure of trade secrets to Senior was sustained in China. Again, we say that's a reasonable analysis and it's the correct approach. 105. Clearly, Mr. Veliks was undertaking acts in Latvia. It's possible that his acts also had an effect and may be regarded as having been carried out in the United Kingdom if he accessed servers that were present in the United Kingdom. Pausing there, that's not what's pleaded. The access to any pleaded case is Latvia, Poland and the Isle of Man. He then goes on, he says there's no evidence at the point, but he should have not even considered it because it's not part of the allegation. There is no evidence on this point. However, following Selgard, I should focus away from this point and instead focus on whether the damage which has been or will be sustained from these acts has been suffered in the jurisdiction. Now, these acts is Mr. Veliks accessing and development. And he's right that he should focus on whether there is direct damage, but he also needs to consider whether the damage, the consequential damage relied on in the absence of any allegation of importation, in the absence of any allegation of downloading or competition within the UK, whether that is in any sense direct damage or, as we would characterise it, and he should have characterised it, the indirect consequence of the act. So he gets it wrong, and then he addresses the case that was advanced before him in the first sentence of paragraph 106. Playtech argues that damage has been sustained in the United Kingdom as it is based in the United Kingdom and trades from there and receives the revenues which may be damaged from unfair competition arising from these breaches in the United Kingdom. That was their case. That's the entirety of their case. And that would just not be enough. But he goes on. Whilst it has not identified competing specific imports, as was the case with the direct claim in Selgard, so no imports identified, this is understandable, as it is a different type of business that does not sell physical goods, but instead sells intangible products. Well, my lords, my lady, that's not the reason why there is no allegation, because there is no pleaded case. It's not about the difference between importation and downloading. It's about, is there any act that gives rise directly to damage in the UK? And there is none pleaded. And he left the tracks when thinking, well, okay, the only basis for that is there's no importation, but I can now consider it in the sense of an unpleaded allegation of accessing some remote software provided from elsewhere. Not pleaded, not open to him. Also, we say wouldn't be right in terms of, you can't just say because I can access this anywhere in the world, that gives me the opportunity to say I am suffering harm in the UK because that's where my company is based. But his approach was flawed from the start in that he should have been thinking about the pleading. Nevertheless, he says, it seems to me that it has got close enough to the direct claim in Selgard that it has presented a strong case that it is facing competition to its business, which it conducts in the UK, in relation to its sales from at least one game that has a feature that has relied on its confidential information. That is not direct damage, even if you assume that were pleaded, but that would not amount to direct damage. Competition to its business, which it happens to conduct in the UK, as a result of acts that are carried out in relation to a now non-infringing, non-misusing piece of software, could in no way be direct damage. And so when he goes on to say, this seems to be a good argument and a sufficient justification for the direct claims that Playtech is making against Mr. Veliks and against Realtime Latvia to pass through the gateway. So We just say he's wrong about that. It's illogical and doesn't work. And the reason he's wrong is, in fact, he's failed to have regard to the pleaded case. But just parsing that, as between Mr. Veliks and against Realtime Latvia, it's not good for slightly different reasons. It's a wrong decision for slightly different reasons in relation to the two defendants. Because Mr. Veliks is not alleged at all to be involved in anything beyond his employment and the development of the games. It's not Mr. Veliks who was previously said in the form of the pleadings in front of the judge to be connected in some way with the Games Global D1, D2. He's an employee of D4. So the claims against him, the direct claims against him, are accessing and development. And there is simply those do not give rise to direct loss, direct damage in the UK. It is at best indirect consequences of his wrong. Now, the point in relation to D4 is simply that it's not pleaded in that sense. We say it wouldn't stand up to scrutiny if it were pleaded, but it's at least, it's perhaps one step closer to a connection in that at least D4 is an entity that had some relations with some entity like C1 and C2, whereas Mr. Veliks didn't at all. So simply no justification for either of the direct claims. And here it maybe he falls into confusion because he's using the term direct claim as opposed to vicarious claim. But neither of those give rise to, they may be direct claims, they don't give rise to direct damage. And then 107, it may be argued that the claim against Realtime Latvia as regards vicarious liability should be treated differently, as this was the case in Selgard, but I don't think that's so, or at least not entirely so. I confess I don't really understand what that point is. At least I don't see how Realtime, so it might be suggested that Realtime Latvia's vicarious liability, if he's right about Mr. Veliks being responsible, then the vicarious liability of Realtime Latvia must go with that. I can't see that there's this distinction, and I don't understand why he says he thinks it's not entirely the case. And then at 108, I think this reveals further confusion. In Selgard, it seems that the claim for vicarious liability for the disclosure of trade secrets was being pursued on the basis that the damage was the disclosure itself, yes, which in that case took place in China. In the case before me, I understand the damage claim for which there is vicarious liability is largely framed by reference to the same damage as for the direct claim, economic loss through unfair competition, therefore passes through the same way as the direct claim. So, my lords, my lady, we don't rely on vicarious liability as providing an escape hatch in this way. It's not, but in my submission that there is some confusion creeping through in the judge's analysis here. And then,
particularly insofar as you say he refers to damage constituted by economic loss through unfair competition, you say, well, that's plainly not direct damage.
Yes, can't be. And then at 109, insofar as the claim, and we say 109, this is their pleaded case. So we say 109, loss is the disclosure itself and indeed the development in Latvia. But this is essentially what was pleaded. Then applying the principles applied in Selgard to that damage alone, Latvia should be seen as the place where the loss is incurred. Darn tooting, we say. That's absolutely the point. However, as the court needs to deal with the claim holistically, I consider looking at the two aspects of the claim, the court should give primacy to the direct claims, wherever, as I have explained, the losses are to be considered to be falling within the jurisdiction. So we just say he's wrong on the direct claims. The correct approach is, in fact, what he says at the start of 109, and he fell into error in not applying it. So, picking up the pace slightly because I must stop at past. The judge then, under 113, applies that reasoning wholesale. Gateway 21, that's fine, it's not a material error that he did it under Gateway 21 rather than Gateway 9, but it's wrong for all the same reasons. There is a point that was run by my learner friend Mr Silverleaf, a textual analysis point that A and B were one part of the gateway and C and D were the other. We don't endorse or pursue that. We don't cavil with the judge's approach on it. So, and then finally, forum convenience, dealt with very briefly by the judge, as is often the case after you've gone through the gateways, in particular because passing through the gateway, a great consideration was obviously the Rome II test of what law applied. So we say a very significant error in the forum convenience analysis was the fact that he was applying the wrong law, and that would have gone the other way. But if I win on that, I've already won on the gateway, apart from in relation to copyright. But he deals with it relatively swiftly. At 121, it's argued on behalf of Realtime Latvia and Mr Veliks that Latvia is the better jurisdiction, as its defence may include reliance on the employment terms of Mr Veliks, Horizon user terms, all of which are governed by Latvian law. As there's no real evidence that Mr Veliks ever signed up to Horizon user terms, I don't agree that the terms contained with the employment contract with one company can govern confidentiality rights of another. Again, we say the focus of the case, everything happening in Latvia, is really just, it's embodied by it's heightened by the fact that the contractual relationship of Mr Veliks was governed by Latvian law. And then at 122, whilst the defendants have put forward some expert evidence as to what claims may be made in the Latvian courts, there does seem to be a lacuna in this advice as regards whether alleged breach of obligations of confidence owed to a United Kingdom company and causing damage in the United Kingdom could be tried in Latvia. I see this as reinforcing a reason for the English courts to take jurisdiction. So we rely on 122 and indeed 124, where he says, having considered the above points and having considered the matter in the round, I consider the English courts are the proper forum in which to determine these claims, and the case that another forum would be more convenient is not made out. This reveals that he'd shifted the burden of proof. Now, burden of proof often makes no difference, but when you have a point in relation to consequence of application of Latvian law to confidential information that is not raised in any evidence, no positive evidence on Latvian law put forward by the other side, and it said that we didn't satisfy this Aunt Sally of a point in our evidence, that can only really be relevant if you're looking at this in the context of the wrong burden of proof, and it's revealed that this wasn't just an infelicitous use of words. He expected my clients to demonstrate that Latvia was the better place for the claim, and that's simply wrong. So he got the burden the wrong way around. And then 123, he identifies practical issues and says there's some advantage to litigating in England and Wales, and in particular refers to the developed regime regarding disclosure. We say, and we rely on that, it's at paragraph 75 of my skeleton going through, I say how this should all be applied. But the grounds of appeal in relation to this forum point, apart from the headline issue that he should have held that Latvian law was the one that applied and then taken that into account, which he didn't, are that he got the burden the wrong way round, that's ground 2A. Latvian law, that's 2B. In ground 2C, we say he wrongly, he erred in considering whether wrongdoing occurred and not taking that into account. So as a connecting factor, if one considers the Annex 4 list, all of the access, it takes place from somewhere other than the UK, all of the alleged misuse, and all of the development took place in Latvia. And that simply doesn't form any part of his consideration of the forum point. So he's not standing back. This is a Latvian case writ large. And he just failed to take that overarching view, perhaps misled by his misunderstanding of direct damage and his failure to properly consider what the pleaded case on direct damage was, but also for all those other matters that I've identified. And unfortunately, we say the judge got it wrong, and we invite you to accede to our application and our appeal, and set aside permission to serve out, so this claim should not proceed here.
It may not matter because it's not a ground of appeal that you're relying upon, but to satisfy my own curiosity, if we look at the last sentence of paragraph 123, was it common ground for the judge that in Latvia, English law would need to be proved by expert evidence? The reason why I asked that question is that the English approach of treating foreign law as a question of fact is a little idiosyncratic, and many systems of law do not take that approach, and therefore do not require necessarily expert evidence as to English law.
My Lord, I'll ask my opportunity to consider the point, and maybe I can address you in reply on it. It certainly didn't form, that was not a point that I ran below saying you wouldn't need expert evidence. We said you could run this all in Latvia. In Latvia, they would hear the copyright claims, mostly focused on the copyright claim, and they would also be able to determine the confidential information claim in general terms, but we didn't address the particular point in relation to damage in the UK, mainly because we didn't...
No, that's a separate question. My question would apply equally to the copyright.
My Lord, yes. I'll check. It didn't... I don't recall addressing the point.
No. Your answer is a slightly different question to the one I'm asking. I understand to be common ground that a Latvian court would be able to apply foreign law and therefore would be able, for example, to deal with the copyright claim. That's not in dispute.
Oh, yes.
But my question is directed to the forum and convenience analysis, because the judge is presupposing that in order to do that, the Latvian court would require expert evidence, and that's what I'm interested to know whether it's actually right.
My Lord, our recollection is that it didn't come up. The judge, that wasn't discussed before the judge, and so it certainly wasn't common ground that that was the case, but it's also not something that, in fact, it's something he's thought of himself, we say. So I'm pleased. There's nothing I like better than finishing my submissions by irritating the panel. It's subject to that point of clarification. Those are my submissions. Is there anything more I can assist you with before I let Mr. Speck stand up?
No, thank you very much.
I'm obliged.
Mr. Speck.
Lords, my lady, what I intend to do, because it is so important for the correct analysis of this case, is to get stuck into cell guard, including the point that my Lord Justice Arnold has asked us to look at first. That's going to take me some time. Then look at how what you see in cell guard applies to this case and how the judge dealt with it. So in effect, dealing with the judgment of my friend's ground 1 and then dealing with ground 2 afterwards. As a headline point before I start that, I do draw attention to the fact that my friend's big point in his skeleton was that what actually mattered was the distinction between the supply of intangible products or tangible goods. A point which obviously doesn't matter at all if there isn't a supply of any goods in play at all. And really, that case has been completely dropped already. And now, the whole thing, in my submission, is going to turn on his look at the pleadings to suggest that there is no separate, specific plea of the words "and you've imported" or "and or you've supplied," when the reality is the pleading is much more general than that. And the submission I do make, my lords and my lady, is that the judge understood it to be of that nature, is encompassing those acts. That is where our market is, after all. And my friend did. That is why he was making the point, seeking to say there is a difference between downloads over the internet and goods which actually came on a tangible form. Now, with that headline point, can we get stuck into cell guard? My friend has taken you to it already, but I do need to look at it in a little bit more detail, because it is absolutely the key authority, including the point on Article 4.5 as well. And as my friend has already told you, it's concerned confidential information for the make-up of products called battery separators. They're highly engineered film articles which are used in batteries to separate anode and cathode. And I think he also mentioned the claim was advanced in both breach of confidence in equity and under the trade secrets regulation. Can we go to 389 first, please? I'm using the bundle pagination. And again, I can take this pretty quickly just to remind you, because I think my friends already covered this pretty comprehensively. The two types of claim that were being identified and considered were called the direct claim, which is the claim which is for the importation and marketing of the product in the United Kingdom. And one of the things that I draw my lords and my ladies' attention to is that it was specifically limited to the United Kingdom in that case, and that's going to be one of the points that I'm going to come on and draw attention to, that I have no express limitation in my pleading, and I'm going to help my lords and my lady on whether that should make any difference. But it was expressly limited in that case, I think because there was only one customer that was understood to be the one that they were touting for. My lords and my lady will understand that that market was not a kind of general public list of users, but specific, I think they were manufacturers of batteries that went in electric cars. So that was the direct claim, and the vicarious claim was a claim, and it was called that because it was based upon vicarious liability, but the key thing was that it related only to the disclosure in China, and as it was framed, the only loss that was relating to that was the disclosure as such. So no economic loss. And the labels used in Cellguard, one can understand why they were used, but what really matters is the nature of what those two different claims were in my submission. Now, having done that, top of 390 should be noted too. Although the contractual obligation of Dr. Zhang was referred to in support of the case the information was secret, no claim was advanced under the contract. Now, before I move on, can I just make one further point about the relationship between the two claims that were brought? The fact which gave rise to the vicarious claims, the antecedent disclosure to senior in China, was obviously a key part of what was necessary to establish the direct claim, the liability for the act of importing and marketing in the UK. But they were two separate acts, and so within the claim, one could see and analyse them as separate claims, in the sense that one was saying there was liability accruing because of each. And I think, having listened to my friend, we're ad idem in that the point that flows from that is that you have to understand that and consider each separately to assess the proper applicable law, and the answer may not be the same for each. And indeed, and again to foreshadow the key point in this case, one might expect the governing law to differ where one is concerned with specific acts that may more directly be linked or more directly impact particular national markets. We are, after all, concerned with a species of unfair competition here. So one would expect that acts that are specifically and directly affecting a country A's market to be governed by the law of country A. Now, if we can continue in my Lord's judgment, the next section addresses the protection of trade secrets under English law, and the passage at paragraph 23 draws attention to a point that I've just alluded to, that misuse of confidential information is a species of unfair competition. And that in that paragraph, my Lord also identifies it's about control of the information and also the applicability of Rome II in answering the question as to the applicable law for non-contractual obligations. Now, my lords and my lady, moving forward, there's a section that comprehensively sets out the provisions of the Trade Secrets Directive and our implementing regulation. That's pages 391 to 394. And whilst we're passing over it, can I just pause and draw attention to the structure of Article 4, because it's relevant to the point that my Lord drew our attention to, and I am going to have to go into it and explain it, and the footnote in Dicey. And the thing that you can see, if you just look at Article 4.3, I'm not going to address the detail now, but I just want you to see it as we pass over. If you look at Article 4.3, it provides that use or disclosure of a trade secret shall be considered unlawful, and then there's one of three circumstances listed, and one is when it was used after it was acquired unlawfully. And the point that we're going to have to grapple with is whether the earlier act being referred to in these provisions as being unlawful, when that was undertaken in a different territory, whether that means the overall test required to be applied is a mixture of laws, the actual main law that governs the wrong that Article 4.3 is directed to, and the law that may be a different law applying to that earlier act, or whether you apply the whole of it having regard to the law that you've identified pursuant to Rome 2. And we come to that in due course, but that's the nub of the point that one has to grapple with. I think it probably arises on paragraphs 4 and 5 of the article as well. But having just flagged up that point on the structure of that particular article, the next section of my Lord's judgment addresses the question of serious issue to be tried, and there was a dispute about particularisation needed. We can skip over that, save for the very last paragraph, paragraph 49, on page 399, that I want to draw my Lord's and my Lady's attention to. And the point one sees from this paragraph is that the vicarious claim, so the claim made in respect of disclosure of confidential information in China, but not said to give rise to anything other than just the fact of disclosure as damage, didn't provide any basis for securing an injunction against importation, or indeed securing damages or on account of profit in respect of them, because it was solely concerned with that antecedent act of disclosure. And my Lords and my Ladies see that my Lord Justice Arnold notes that here Senior had nonetheless accepted sensibly that if permission to serve out as regards the direct claim, there should be permission for the vicarious claim too. And there's an obvious reason that's sensible, because although formulated as the vicarious claim, and therefore not one which would form the basis of getting through the gateway, in fact, probably not form the basis of a claim for any substantial damage at all, the facts that make it up are key and necessary, as I alluded to earlier, to the claim that is going through. So put another way, it arises out the same or closely connected facts as the direct claim. So although the wording of Gateway 4A isn't drawn attention to, that's why it's so sensible that you would leave that in as well. But what my Lords and my Lady must note, it went by concession in that case. But that's the substance, certainly as I read it, of what's going on there. Now, we come to the key section next, headed Applicable Law, and the first few paragraphs identify the applicability of Article 4 of Rome 2, which my Lord sets out at paragraph 52. And as my friend alluded to, the key point is the governing law is the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and also irrespective of countries in which indirect consequences of the event occur. So it's direct damage that we're concerned with. And then my Lord sets out Salgard's contention that was accepted by the judge, the damages in the UK as Selgard's market here will be damaged by importation and marketing here. And the argument for senior is set out in the long paragraph 57, basically to the effect that it's Chinese law. And my lord, as my friend has alluded to, rejects that contention right the way through pages 401 to 402. And I want to pick out just a few of the points my lord makes. First, the absolute key point in my submission is in fact the fourth point in paragraph 61. It's more fundamental than the earlier points, which are directed to dispatching the relevance of particular authorities being relied upon by senior. The fourth point meets the submission that it's desirable to locate the direct damage caused by misuse of confidential information in a single country. In other words, to treat all damage in different countries as if it was actually suffered in one, presumably because it's caused by repeated similar acts. That is contrary to the approach laid down in Rome 2 itself. Specifically Article 6 that explains Article 4 applies, and Article 4. And my lord refers to the explanatory memorandum that specifically explained in relation to what became Article 4 that where damage is sustained in several countries, the law of all the countries will have to be applied on a distributive basis, what the Germans called Mosaic Betrachtung. One can get a feel for what they're talking about by that term. So you're concerned with several countries, you apply the law for each of them relating to the acts causing damage in their own country. Now my lord goes on after the quote to refer to a further extract which specifically which refers specifically to Article 6, so the provision concerning with unfair competition, providing the connection to the market, to the law of the market where the competitors are seeking to gain customers' favour is the connection one should be looking for. And the extract goes on and refers to only direct substantial effects being taken account of, and this is key, explaining that in international situations, anti-competitive conduct commonly has impact on several markets and gives rise to this distributive application. So this is expressly stating that where one has a form of anti-competitive conduct which crosses borders, one should separately apply the local law of the markets directly affected. So it's saying precisely the opposite of the submission that had been made to my lord by senior, that you should consider it as all located in one place. Now, my lord's fifth point builds on this, and I think my friend mentioned it in his submissions as well, that you identify the point that the market affected by the specific acts of unfair competition, it doesn't matter that the product is manufactured elsewhere, in that case China. And my lord goes on in the sixth point, this is paragraph 63, to draw support from Lord Justice Evans in Kai Technology, because the point his lordship made in that case as being absent in Kai Technology was precisely what was present in Selgard. Now, can I just pause and say, the effect of all of this is that for non-contractual obligations, specifically forms of unfair competition, it really matters what's within the scope of what's being claimed for. And a broad course of conduct may cover acts like an initial wrongful disclosure, a subsequent use in designing something, further subsequent acts of manufacture, and then a series of similar acts of importation and sale or supply of products in particular markets. And one has to have regard to each of them, and specifically, as regards the latter ones, what direct damage arises in different markets as regards for each. Now, the consequence of that is not just that different acts of sale and importation may be subject to different laws, but also earlier acts of acquisition or use may also be subject to a different governing law. And one has to have regard to the fact that that may be the outcome. Now, I've paused to make those general points before moving to the 7th point, and that's paragraph 64 on bundle 402, under page 402. Because the point my lord makes there is a specific point about a situation where a country of manufacture and a country of sale, where the country of manufacture may have weak trade secret protection. And I wanted to address that point by pointing to the fact that, in fact, this consideration is broader. And the simple point that my lord deals with here was a point made by Mr Saunders, that Senior's position led to this improbable result. And that the improbable result is that you get away with it if the initial upstream act is in a country with weak protection, even if the law where you're in the market would deem it to be unlawful. And the point is a good one, but it actually goes further. It will operate the other way round as well, my lord. And by that what I mean is, if you treat the antecedent act as determining the lawfulness of everything that happens the other way round, if you have a country with really punitive laws, you can see that you end up with a position where the initial act is unlawful in accordance with that place, and an argument that you have to treat any subsequent acts, say of importation of sale, which are in a country where the that initial act would not be considered to be unlawful, as unlawful because of that. And that's actually a point that we see that Lydia Lundstedt makes in her book when we come to it. So it's a broader point, my lord, and the problem that is actually at the more general level is that what it ends up doing is requiring everything downstream to treat the acts that actually pertain to its marketplace as lawful or not, depending upon the law of somewhere else. Now, there is a further detail, and it's quite a significant detail that we have to deal with, which we come to in the next series of paragraphs, which is 65 to 67, and it's the rather knotty point that my lord drew attention to. And I want to deal with that very shortly in a minute, but before we do that, I very briefly skip to paragraph 68 to see how the analysis we've been working through worked for the other claim. So I'm going to come back and deal with the issue in 65 to 67 in just a minute, but 68 addresses the vicarious claim. You'll recall it's the disclosure to Senior by Dr. Zhang. And about halfway through the paragraph, my lord explains the conclusion is it's Chinese law. That's because the direct damage caused by disclosure, insofar as there is any, and that's an important qualification you're making that illustrates that the direct damage will likely be more substantial from the importation and sale of products claim. But insofar as there is any, mere disclosure without more, it is not very much damage, as your lordship is recognising. But that is happening in China. So the conclusion on this paragraph is that the applicable law for that other claim is China. But as I've showed you earlier, it was accepted that if they got through the gateway on the main claim, that would come in this case here by concession in any event. So in a sense, what I've covered so far is kind of the easy bit. Can we go back and grapple with the point my lord addresses in paragraph 65 to 67. And as I understand it, it's not a point that impacts the claim for breach of confidence in equity directly, but it's a specific point on the Trade Secrets Directive. And it is the point that my
Well,
Lord...
that's true, but what, does that matter for our purposes?
I suspect not, but we have to be quite careful with the analysis. So,
Indeed we do, but the definition of trade secrets in the directive is pretty broad.
indeed, absolutely. The only reason I mentioned it is because it is a specific point on the structure of the directive, and which obviously has been implemented in an incredibly brief way by our regulation, and the claims tend to be brought
Well,
in.
that also is true, but again, do we need to be concerned about that?
No, but so we tend to look at the directive, but strictly it's a point that only applies to one half of the claim, I think, and the one that's made under the Trade Secrets Directive.
Sorry, is it just for my benefit, the regulations implementing the directive do they create causes of action?
No, they don't.
Or is it just a question of applying our own principles in accordance with the directive?
Well,
I think I'd understood it was the latter.
I think
So it's not really an independent cause of action at all.
I think you're right about that, although the problem, as I think my Lord Justice Arnold pointed out,
So this is addressed in paragraph 29. If it matters, which I don't think it does, the answer is the question is discussed in paragraph 29 of this judgment.
it pretty much just says that it's an infringement of the regulation to breach confidence. But I think my Lord is right that it probably won't matter as a practical matter, but it is a point directed specifically to the structure of the directive that I'm addressing, and my Lord was addressing in 65 to 67. And it's the point that Dr. Lundstedt addresses in her book, ultimately expressing a view to the contrary to the one that my Lord expresses here in 65 to 67. And can I start by identifying what the issue is? My Lord explains it in paragraph 65 by reference to Article 4.5, and that article's reference back to paragraph 3, specifically in one of those sub-paragraphs as a reference to the earlier unlawful acquisition of the trade secret that I drew attention to earlier. And so it's that point that I tried to flag up earlier. Even if the law of the market, which the alleged unfair competition is occurring, is applied, does it, as a separate matter, require a different law to be applied to the Antecedent Act, insofar as the Trade Secrets Directive refers to and requires an earlier act to have been unlawful? So the two options, well, in fact, the three, if one sees the submissions that were made in Selgard, are: do you apply the same Rome II Convention answer to the whole, so consistently apply the law of the market into which the article is imported, or do you separately...
The first question is whether Article 4.3a is an implicit choice of law rule, given that on its face it doesn't appear to be any such thing.
Yes, and it's quite interesting actually, my Lord, because Mr Abrams, I think, who was arguing it for senior, tried to say yes it was, and it isn't, and now part of the way in which the argument against my Lord's view is put in the book is that you're saying it is by coming to the conclusion that you do, and it's one of those points. Is it a choice of law point, which an opponent seems to say is part of the argument of somebody that prefers the opposite view to the one I'm preferring. The submission that I'm going to make to my lords and my lady is that it's not, but that doesn't help you, because either argument can be advanced without saying that that is a choice of law clause.
So you are not going to say that Article 4.3a is an implicit choice of law rule.
No.
In which case, it must follow that you accept, I think, that choice of law is to be determined in accordance with the Rome II regulation.
Yes. But ultimately, my submission is that my lord was right on the substance of the point. There are a couple of other criticisms that Dr. Lundstedt makes, in particular in identifying which subparagraph of 4.3 the particular claims fall within, that she has a point on. But ultimately, submission, and it's going to take a while to go through it, but ultimately my submission is that my lord is right, just so that you know where I'm going. But I also understood from this decision that it probably wasn't something that counsel thought of before the hearing.
No.
And
well, hence the comment about
exactly
preferring to have had more considered and detailed submission.
Yes, and I was hoping to be in a position to give my lord and my ladies that help.
Can I just understand also where you're going? Is this relevant? How is this relevant? Are you going to explain?
How's it
It
relevant?
is.
Well, ultimately, my answer to that question is it's not actually for a reason which wasn't touched upon here, and that's because even if an earlier act has to be looked at under a foreign law, that doesn't mean that the act that you're concerned with isn't the subject of English law. And you'll see that...
Well, you've made that point already by reference to...
Yes, but even the criticism of my lord's approach accepts in an example that's given that there's a main law that's applied, which is the Rome II, and it simply becomes a debate about whether or not there's a separate preliminary question you have to go off and answer.
But if you say it's not relevant, then we don't need to go into it, because in that regard, you're at one with Mr. Moody Stewart, because he says it isn't relevant either.
Oh, well, he says it's not relevant for a different matter. He says it's not relevant because you never get into Article 4.5 going back to Article 4.3. I say you do, but the question on governing law under subparagraph A isn't relevant because on any view there is an overarching governing law which is English law. Subparagraph A only requires one element to be looked at under a particular law. I say you're right and it's English law as well. So I say it's not relevant for a different matter. I do not say that Article 4.5 and its reference back to this is not relevant in the way that my learned friend does.
So you say this is an Article 4.5 case?
Yes, it includes within the scope of what I accept is a broad pleading, but the thrust of it is the acts where the importation is coming here, and my friend has changed his case from saying that what actually...
Don't worry about whether he's changed his case. So your case is that this involves, your claim involves the production, offering or placing on the market of infringing goods.
Yes. And
what are the goods?
And that's what you would fairly understand looking at the pleading. The judge understood that that's...
What are the goods?
The goods here are the software, and the distinction between Cellguard and us is that it's intangible, that it's downloaded when you go on your phone or your laptop to play. It comes down the internet connection, and that's the point that was being put against me in the skeleton.
Understood.
So I do say that it matters.
So your case focuses upon downloads into the UK.
Yes.
At some point, you're going to show us where that's bleeding.
Yeah, well, I'm going to look at the pleading, but I absolutely accept that it's very general. But it's within it, and the focus of the damage and the relief is the ability to be on the market with competing software. This is not about software which is developed and doesn't see the light of day. it's not about the fact that my client is based in the United Kingdom, but it is about the fact that my client's market, the centre of gravity of it, is here.
All right.
Are you going to address argument to us on the proposition that software is goods for the meaning, within the meaning of the directive?
I wasn't going to.
Well, if you're relying on Article 4.5, you have to. It's inescapable.
Because it's not obvious to me as a matter of English law. The Sale of Goods Act, for example, would apply to the sale of software. So if the directive has a different meaning, I would like to be addressed on it, even if briefly.
It will be brief, but I will address it.
Thank you.
Very good. We'll resume at 2 o'clock.
Rise, table.